and welcome to Module 3. I'm Dr. Galliano. Our topic for the next 2 weeks is going to be legal information and literacy. Now, as we get started here today, one of the first questions we're going to answer is, well, what exactly is information literacy? Before we do that, in Module 1, we learned what we mean when we refer to the law, including the sources that contain information about the law. And then in Module 2, we learned about the different places where we can find the law. And you even got some practice finding the law in your first deliverable assignment. Now we're put on our information technology cybersecurity hats, and we'll focus on users, the people that we're actually trying to help. These users may be patrons in a public law library, students at a law library, or even your co-workers at a government agency or some private corporation. The big thing is we must consider the importance of our role as an intermediary. You can think of that role as something like a bridge between people and legal information. So in this lecture, then, I'll be talking about 2 different populations that you may find yourself helping with legal information. These populations have very different needs and often very different levels of information literacy, and specifically legal information literacy. They likely will have different levels of comfort when it comes to the law as well. The first population is the public. This is a diverse group that have wide-ranging and sometimes surprising needs related to legal information. And the second group is law students, who tend to be a more homogeneous group. And as you probably already know, these law students, they've all graduated from college and have demonstrated interest in the law, or at least we hope they do since they're in law school. Now, before we talk about these 2 populations, we should review the concept of information literacy, which is really the core of this module. Now, on the screen, I have for you the broken down definition of information literacy as defined by the Association of College and Research Libraries, the ACRL. And there are some key points there. Now, this has been elaborated on in many different ways. But in general, these definitions center around a common set of ideas or concepts. Now, the 3 key elements are the reflective discovery of information, understanding how information is produced and the value attached to it, and then the use of information in creating new knowledge and participating ethically in the communities of learning. So that's information literacy as defined by ACRL. Now, the information literate person, though, is able to process information. That's a key takeaway here. And the infographic that you see to the right of the bullets is useful in the idea that it helps us conceptualize information literacy as a process, okay? So it is that process of attaining knowledge. Now, you've probably encountered some other behavioral models in INST615. And I think in each of these, what we find is that information literacy is iterative. And the development of information literacy skills, we cannot say that that's a linear process. So at the beginning, we must determine the information need. That's what you see in step 1 there, if you will, or the part of the pie that's colored blue. And that need then is what drives the process of accessing information. And evaluating sources, incorporating what we learn into our knowledge base. Establishing the need helps us frame the task effectively, and generally that's to answer a problem, solve a question, solve a problem, or make some kind of a decision, right? Those are kind of the three things that we go seeking for information about. And then while we're going through these various steps here in this process cycle, ideally, we are aware of our own responsibility to use and share information in a legal and ethical manner. And that's the part of the chart there referred to as 4. Oh, now thinking about legal information specifically, we start with a slightly different premise, and that is that just identifying the information, legal information, that presents certain challenges. If we focus in on one of the two populations I mentioned a minute ago, like the general public, I think the simple fact we're confronted with is that everyday life information needs generally have some kind of a legal dimension to them. We may not even be fully aware of that. And then in terms of law students, it's a little bit different. It can be a matter of, say, choosing a topic for a research paper and then being able to identify the relevant legal issues and or, the crux of the law at the center of some issue. Now, as information professionals, we play a vital role in helping people articulate their information need. Again, I should bring to mind INST615 and specifically the idea of question negotiation. So if you're not able to identify and articulate the information need, then it's easy to see how your search for information could yield unexpected or even poor results. And then I'll also say that it's hard to access information if you don't know what you're looking for. You tend to go down rabbit holes. And particularly when you're dealing with legal information or medical information or cybersecurity information of a technical nature, really anything closely tied to a specific profession or occupation, then that information literacy challenge can be pretty substantial. Now, if we frame it as medical jargon or legalese, then that definitely can become a barrier to access, right? And it can be one that's tough to overcome. And that's why the timely intervention of an information professional can be so helpful to the public. All right, so let's move on then. So let's start with the public then. For many people, they tend to be, living their lives, and then suddenly they're finding themselves having to make sense of some legal issue, or some legal issue has confronted them all of a sudden. And there's many examples, but it could be a dispute with your landlord, you've gotten in a car accident, you sign a prenup with a future spouse, you engage in some real estate dealings. All of those things have a legal component, right? But because of the general public's lack of an in-depth understanding of the law, then what comes with that is anxiety and apprehension. They understand that legal issues are complex. They understand the consequences are high. And therefore, I think that just about any of us has either personally or through someone that you're very close to have experienced this in the past. Now, these things may seem like simple legal issues, but what tends to happen is they get spun out of control. And a major reason for that is, let's face it, our legal system is complex. It's not necessarily designed to be navigated by laypersons, and especially laypersons who tend to go it alone or not seek legal counsel. Now, there's also this idea of a justice gap. More and more people have been doing just that, what I just referred to, trying to navigate the legal system without the benefit of counsel. And so what has arisen is a justice gap as we see that the number of people needing legal services, without a proportionate increase in the amount of resources available to provide those services has arisen. All right, so now there's this gap between the availability of resources and the need. But we do need to note a couple of things here. We're not talking about criminal cases when we talk about a justice gap in this specific context. As you know, the Constitution does guarantee a right to counsel when you're a criminal defendant, but there is no equivalent right when you're a party in a civil proceeding. That notion does not exist. And so this idea of the justice gap plays a big part. Now, in response to this somewhat troubling situation, court systems and legal aid organizations around the country have grappled with this and begin to tackle it by trying to use technology as an enabler. And that's where we come in. This has led to a proliferation of online resources and services, particularly aimed or targeted at self-help users. But one problem with these services is they may not be as tailored to specific legal information needs as the traditional face-to-face consultations that a legal aid organization or a counsel would provide. Now, the idea behind these online services, though, is that at least some legally based information can be provided. Some level of service that doesn't require a formal relationship. And so you can self-educate. You can become better prepared and equipped in that goal of navigating this complex legal system. Now, the Washington State Access to Justice Board in 2004 on your screen is a quote that I got from them. Pardon me for 1 second. I thought that this was a very applicable quote. Now, underlying all of these initiatives, though, is a commitment to access to justice, which is fundamentally the backbone of civil legal aid, and this is captured by the access to justice technology principles that the Washington State Judiciary developed. And in fact, many believe that they have led in this area. Now, access to justice requires that the public have available, understandable information about the justice system specifically, its resources and means of access. The justice system should promote ongoing public knowledge and understanding of the tools afforded by technology to access justice by developing and disseminating information and materials as broadly as possible. And we can see how the concept of information literacy is threaded into this. Washington State, in their quote there, we're talking about not only providing access to information, but also ensuring that users comprehend that information. And so this should hopefully bring to mind the different levels of access that we talked about in the Module 2 mini lecture. Now, why is this important? Because it's one thing to show someone how to search online for a case. It's quite another, though, to give them the tools to understand whatever information they find. All right. Now, in response to the demand created by the justice gap, libraries, and particularly public libraries, have begun to define a role for themselves in access to the justice movement. Libraries have traditionally served as community access points. Thus, they are, naturally well positioned to connect self-help users with the information needed, legal information. But there is an issue, right? Many public librarians don't have a background in the law. They may not even have familiarity with legal information. And then this can naturally lead to some reluctance to delve into the entire world of legal information. And it touches upon those ethical issues we saw in the process of information literacy a few slides ago. Now, despite this understandable hesitation, public librarians have slowly but steadily become more comfortable with the role of being an intermediary or navigator, and have stepped up in connecting self-help users with legal information that they need. Librarians take an approach similar to what they do with respect to any other body of information, and that is to reduce or remove barriers to information access. And there can be a lot of barriers. A few of those are on the screen. For example, technology. Libraries help by providing physical access, loaner Chromebooks, laptops, terminals for the web, and so on. Can also include printers, but it may also include Wi-Fi access. In fact, a nearby library to where I live in Anne Arundel County provides hotspots and Chromebooks on a loaner basis. Now, this kind of public infrastructure, at least in my mind, can be a real game changer, right? So if a self-help person need to respond to a petition filed against them, or, they have to go to court for some other reason, and they don't possess technology, or it's not feasible for them to do so on a smart device, then being able to tap into what the local library offers, it really is a game changer. Digital literacy is also relevant, though. Navigating court and online filing systems can be challenging, in part because these systems look very different depending on the jurisdiction. Even with your first assignment in which you looked for various resources and libraries in your area, what we saw across the board was there are no two alike, right? And that leads to not very much in the way of uniformity. So I think what we can probably infer here is that neither legal information nor the legal system is generally easy to understand if you are a legal outsider. So even if you have access to technology, and even if you found the collection of forms on a court's website, there's a good chance that your library patron won't know which form is appropriate, what information needs to be included on the form, what the process looks like once the form is completed, and so on. And that's really kind of the nuts and bolts here, right? It's one thing to seek self-help information. It's one thing to educate yourself on legal, proceedings and laws and things like that. But it's quite another when you have to apply that knowledge. Now, the fact that they may not be able to apply the law to their personal situation becomes tricky for librarians, because there's a limit to what can be done. There's parameters around the acceptable level of assistance that a librarian can provide, and we'll talk about that obviously in the next module. For now, I'll just say that if we think of the role of librarian as an intermediary or navigator or bridge, and not as an advisor, then that should help clarify things for you. And that's what we really need to be thinking about when we think of these kinds of limits and the scope of help we can provide when people have legal information needs. All right, let's move now into legal information literacy and legal professionals. The second group of people that I wanted to talk about are the legal professionals, and I specified law students. Now, this population or group knows much more about the law, even if they're just in their first years. They're much more comfortable in this arena. They know some of the jargon. They know some of the technical aspects. They have a basic understanding of how the system should work, and are already becoming knowledgeable with legal terminology. And thus that makes them better equipped to find and apply legal information to a case that they're helping out on in a clinic or a research project they're working on. It doesn't mean, though, that there aren't still challenges that we need to think about when assisting this group. Now, from the perspective of an information professional trying to help legal professionals, the primary challenge for us is helping them to become competent legal researchers. Unlike members of the public who are probably only dealing with legal information sporadically, we can't say that about this group, right? It is the heart of the profession for lawyers and law schools or their training grounds. So I want to present to you then the AALL's Principles and Standards for Legal Research Competency. Now, there are 5. Now, considering the principles you see on the slide, the connections to information literacy should be clear. Principle 2, for example, gather information via effective, efficient research strategies. That definitely applies to a successful legal researcher. Principle 3 focuses on the evaluation. 4 focuses on applying the information to a specific situation. And 5 focuses on that ethical and unethical uses of information. All of this should bring to mind or remind you of the information literacy graphic that we looked at earlier. Now, as I reviewed these principles, it occurred to me that a law student who can do all of these things has a solid level of legal information literacy. It kind of follows, right? What we hope to accomplish, though, when we work with these kinds of students is through library sessions and consultations, is to help them develop the skills and that they acquire and maintain a good, solid level of legal information literacy. So that when they do go off and become quote-unquote real lawyers, and they're working in firms or government agencies or legal services, nonprofits, they're able to effectively conduct legal research. That's the big outcome. Now, what has come to light in recent years through some research studies is that many law students and lawyers are actually not so skilled when it comes to legal research. And in many cases, these students have gotten through law school without developing strong skills in the area, but they manage to pass the bar and they go to work. And what research has uncovered is that their employers are quite dismayed at their lack of preparation in the area of legal research. And so the question becomes, what can law schools do to better prepare students in this regard? Now, one of the things I've been talking about is how these standards resemble the information literacy standards that the ACRL developed prior to the framework that was adopted in 2015. These previous standards focused on skills building, which kinds of looks like what we have up here on the slide. And this is good to the extent that we can think about how to assess whether students are in fact developing these skills. And then we can think about how we can measure success in each of these principles or areas. Now, a complicating factor is that in most law schools, legal research education is not very extensive. Now, there may be opportunities for students to take advanced classes in legal research, but because of the way law school curriculum tends to be structured, the only required research class is taken in someone's first year, and it's often connected to some sort of legal writing class. So it doesn't get reinforced over time. It gets kind of assumed that those skills are developing over time, and that may not be the case. Now, in the rest of that curriculum and those continuing years, what happens is that the research instruction focuses on a specific content area. Choose one: taxation, product liability, so forth. They're not really law students given a lot of opportunities to develop their research skills in a broader way. And the structure of a legal education is often given as one of the main reasons why many law school graduates are not skilled researchers. Now, it becomes a complicated problem just because there is so much content in law school curriculum. It's tough to get everything in. And so if you're going to think about increasing the amount of research instruction, it becomes a zero-sum game. So you're going to add that, you got to take something else away, right? And it becomes an expense or a bill that often is not academicians are not want to do. So what could we do? Maybe we rethink how we view legal research competency. And maybe what needs to be done is something like what, ACRL did when they created the framework for information literacy. Now, let's take a look at that framework. If you're not familiar with this framework, it looks a lot different than a list of clearly laid out standards. It's more of a holistic approach, number one. And it assumes that information literacy has been extensively studied, critiqued, and even criticized. It's been the subject of a lot of action type of research. So, for example, can we take the strategies that are really smart academic librarians are using to help college students to develop their information literacy skills and apply them to this narrower law school context? Maybe, but I'm going to focus on that a little bit. So the first thing I'm going to talk about is searching as strategic exploration. This deals with the realization that the legal resources that are available are going to vary in terms of format, content, and relevance, and depending upon your needs, the scope of the problem, and so on. That's strategic exploration in terms of legal resources. And that brings us back to the core concept of defining an information need so you can develop a good search strategy. For example, let's say you're a summer associate and you're working on a case at a law firm. You are presented with a legal issue with which you're unfamiliar. And so it's important to be able to identify sources that are going to be most likely to be helpful and to have some idea for how to effectively search within those sources. Now, to the extent that law school education can help students better answer the questions that are up here on the slide within a particular context, this would be enormously helpful to the legal profession as a whole, I think. This should help lawyers to be more productive from the beginning of their career and then going forward. And ultimately, this should lead to better results for clients and others for whom they're working, right? And so take some time to reflect on this searching as a strategic exploration and these questions. All right. So that ends the lecture for Module 3, and I will see you in the discussion forums. So long.